Don't thank you, Chair.
Okay, excellent. Senator Roberts, do you have the call?
Thank you, Chair. Thank you, Ms Perks and everyone from Coal LSL. Mr James Joseph was injured on BHP's Mount Arthur coal mine on 7th of June 2023. You familiar with James Joseph?
We're familiar with James Joseph, yes.
With what?
Sorry, yes. Familiar with the individual, yes.
Coal LSL have confirmed with Mr Joseph that they were not informed of his workers' comp status, which was approved in May 2024 following a 6-month delay. Mr Joseph's correct workers' compensation status seems to not have been reported to Coal LSL by the BHP or their insurer, Coal Mines Insurance. Coal Mines Insurance has the board of directors has 50%, as I understand it, 50% mining and energy union directors and 50% coal owners.
Senator Darlene Perks, CEO of Coal Long Service Leave. I'll answer the last part. So the shareholding of Coal Services, I think, is what you were just referring to, which is the workers' comp.
Coal Mines Insurance?
Yes, yeah, it is. I can confirm, not an organisation, obviously, that we have any relationship with in our jurisdiction, but I can confirm that the shareholding is, as you've reflected, Minerals Council and QIC, and CFMEU.
That's the composition of the board, 50-50.
Our board?
No, Coal Mines Insurance Board.
I can confirm. I think they do have independent directors, but that's
What about your board?
Our board? So our board, the legislative framework hasn't changed in all the hearings that we've been. So our board has 6 directors who are appointed by the responsible minister. 3 directors are nominated by employer companies bodies, and 3 directors are nominated by union organisations, but minister appointed.
Thank you for correcting that, but it's 50-50 again.
Our minister, our director
board,
composition?
Board composition.
Yes.
50-50 employers and union. Okay. What is being done to rectify this particular case, and is this a common occurrence, that is, employee is medically terminated whilst on workers' comp and Coal LSL are not informed by the employer or their insurer? This seems, by the way, very similar to the mistreatment of Mr Simon Turner by BHP and his employer at the time, the labour hire firm, Chandler McLeod. What's being done to resolve this, and is it common?
So the scenario of, we're talking termination, and I've tried to explain that in a couple of hearings over the years as well, but I'll appreciate there's a lot of new members. I'll explain the process again, and our GM Legal, Michael Dowser, might be able to add to the process. But the employer will advise us through their monthly levy returns a termination code for the employee. One of the reasons for termination can be for ill health. Others would be redundancy or cessation. So that process hasn't changed. That is the legislative arena that we operate within. Nothing has changed from the explanations over the years in regards to how do we collect the data, how does the employer advise us, and then how do we verify the data through the relationships and interactions with the employers.
So that was one of the problems that Coal LSL was encountering, lack of verification of the data. I'm not saying you didn't do this here, but so it's common then for someone's employment to be terminated but still be on workers' comp.
I can't talk to the commonality of that, Senator, in regards to the data, but I said the reason for cessation will be advised to us from the employer.
But sometimes the employer won't tell you, won't notify you.
They will notify us of a reason of termination.
Yeah, but sometimes they won't notify you that he's actually been terminated.
Would you like to add to that, Michael?
Yes, Michael Dowser, General Manager of Legal. The notification comes through our levy form, and they identify when employment has ceased, the cessation code, which indicates the reason for termination. So that is a reporting from the employer. if subsequently there's an issue in relation to that, we'll engage with both the employee and the employer to seek to understand that issue. But ultimately, it's to be resolved between the employer and the employee.
Okay. So the question was, is it a common occurrence that an employee is medically terminated while on workers' comp and Coal LSL are not informed by the employer or the insurer?
What we are notified of is the cessation of the employment. There's no requirement to notify us in relation to any other details in the employment relationship.
Okay. So in your experience of checking up, it's not really common that you're not notified?
I think the way I'd answer that is in relation to complaints. So it hasn't come through. Your question is it a common occurrence? No, we don't have volumes of complaints which would illustrate a systemic issue in common occurrence of employers advising us of termination codes which an employee doesn't agree with. I know there are a couple of cases, and certainly we've had a lot of conversations around those, but I wouldn't say it's a systemic issue that has been understood through volumes of complaints for the scenarios that you're talking about.
What are the, and I'm not accusing you of governance issues at the moment. We've sorted them out hopefully after the review. What are the implications when this occurs? For example, an impact to levy payments because the employer no longer paying, super payments, internal workloads of Coal LSL to investigate and resolve such matters. Does it put a burden on you?
So the scenario that if it's found that an employer has advised us of a termination code that an employee disagrees with, certainly the resource from the team to engage with the employer, engage with the employee, assess information, etc., and if that is unresolved, then we would be advising the employee to take it to the Fair Work Commission because we'd be classifying it as an industrial relations dispute, which is out of our jurisdiction.
So if the companies fail to notify Coal LSL within a reasonable period, what would normally come of it? For example, 6-month failure to inform you, as in Mr Joseph's case. Well, what happened there? 6 months BSP didn't inform you.
So I'll talk about the obligation under the Collection Act, Senator, that the employer has an obligation to submit a monthly levy return. So that is a statutory obligation. In regard to correcting or working through a disagreement or a dispute in information that we've received, that would be a process which isn't, I'll say, time-bound in our statutory frameworks, but the employer has an obligation to inform us monthly of employee service and any other critical information such as terminations, eligible wages.
So if this is proven to have occurred by a registered organisation, what intervention or penalty or enforcement would Coal LSL apply under its constitution to deter recurrence? Is there any?
The key obligation is to submit a monthly levy return with correct information. We are reliant on that information in terms of being able to conduct any further inquiries. If an issue is brought to our attention by an employee, we will engage with the employer and seek to get the employer and the employee to resolve that issue and communicate the outcome to us. We don't have any power to adjudicate on that dispute.
No consequences on the employer.
If there is an incorrect levy return, then there could be consequences, but that is a factual matter which we would not have evidence of.
Could you please advise why Mr Joseph's Coal LSL number looks to only exist from September 2022 onwards, as per his Coal LSL commencement letter recently provided to him under Freedom of Information? Why is the specific reason for the delay in creating his Coal LSL member number? Or what is it? What is the specific reason? Why was?
I think we'd have to take that one on notice,
Okay.
Senator, and have a look at the time frame of his records and provide a response on that review.
Mr Joseph has been provided information under an FOI, Freedom of Information, that shows Coal LSL levies were paid by BHP to Coal LSL as early as July 2022. However, his welcome member letter was produced in September 2022. Why was that?
So we'll
Same
take
again?
that one on notice.
Is it possible for levies to be paid when an identification number does not yet exist?
Yeah.
The levy return, when the levy return identifies a new employee, we will take that information and effectively create a record for that employee. Our obligation is to keep records.
Then you get an identification number out of that.
And there is an identification number which will be created at that point at which the employee is first put on a levy return.
So it wouldn't be possible for levies to be paid when an identification number does not yet exist?
The first time that a new employee is properly identified on a levy return would be the point at which we would commence a record for that employee.
Yeah. Okay. Mr Joseph requested all company audits provided by BHP to Coal LSL for the entire period of his employment, 2011 to 2024. I don't think he was continually employed at Mount Arthur for that period. I think he was involved in other divisions of the company, including Western Australia. Why was he only provided with 2 years, considering Coal LSL are reviewing his open recognition of prior service application for periods that fall within this Freedom of Information date range, 2011 to 2024?
Senator, can I take that one on notice as well? I do know the FOI case. I can't answer without going back to the reasoning as to why that information was provided and some wasn't, but I know that the team work within the jurisdictions of FOI, so we'll take that one on notice and provide a reasoning.
That's fine, Ms Perks. The December 2023 Coal LSL BHP external audit report indicates potential discrepancies in reimbursement amounts claimed by BHP. Has the investigation into this matter been completed? This is 2 years later. Has it been completed?
That's their audit report. I'd say, Senator, it's quite common through the receipt of or the process of that audit work for employers to have adjustments in reimbursement claims or levies. And it's through that audit process that the reimbursement, if it's overclaimed or overpaid, would be rectified, and similarly, the levy payment would be rectified. I won't answer without being able to check with the team that has been closed out, but I'd be very confident it has, with an audit report dated December 2023, that an action from the audit report submission would be closed out as our administrative processes
Perhaps you could take this next. Thank you. Perhaps you could take this next one on notice then. Was this in fact found to be a confirmed finding, that is, BHP claiming illegitimate reimbursements, and if so, how significant were the findings of this discrepancy?
Illegitimate, that's a strong word. What we do find with, again, if I take us back to the process of the employer, it is a self-reporting scheme. So the employers, through the submission of monthly levy returns and then the reimbursement claim process, will be calculating based on our guidance of how to calculate levy payments and also how to claim the reimbursement under the reimbursement rules. It is very common that employers get it wrong. It's a complex administrative process, so it is quite common that through the external audit function that we do rely on for the assurance of the correctness of levy paid and reimbursement claim, it is very common there'll be an adjustment. So I wouldn't typically classify that as illegitimate or deliberate actions. We would typically see that as human error on the employer's side, and then the audit process provides the assurance to then get the adjustments correct.
Is this a disclosable matter, and should it? And was it? If it is, was it disclosed in the Coal LSL annual report for fiscal year, financial year 23-24?
No, that's not a disclosable matter, okay. Senator. As part of the no, it's not.
Thank you. Is it true that BHP did not pay any Coal LSL monthly levies from any of their owned entities to the Commonwealth Coal LSL Fund between the period of November 2015 to November 2016?
I would take that on notice, but I'd find that fact, I would be very surprised to find that they hadn't paid levies. I would be very confident to say they have paid the levies, but we will take that on notice to answer your question.
Something in my mind reminding me of that might have been proven in the Iron Mountain document. Can you recall that? I can't.
The
Iron Mountain document.
I'm not familiar with that document.
And could you also tell me what was done about it, please?
If it wasn't paid?
Yes.
Yeah. Yes.
Was that approach consistent with the Coal LSL constitution at the time, and were any penalties applied? If you could tell us that as well, please.
If an employer hasn't paid levy in line with their obligations under the Collection Act, the levers that we have available is to charge an additional levy. It's an interest calculation. That is the lever that we'd have available to us.
Okay. So we have got some penalty provisions.
We do have some penalty provisions.
BHP and Coal Mines Insurance previously refused to acknowledge Mr Joseph as a black coal industry covered employee, challenging him on this as recently as July 2024. Yet Coal LSL have received levies from Mr Joseph since July 2022. Can you explain how and why this would occur from Coal LSL's perspective? I've got my thoughts on it.
Other than taking
notice? My position on that is for the purpose of compliance with our scheme, the inclusion of an employee on a levy return is a statement by the employee in relation to eligibility under our scheme. Matters relating to other issues of employment, we do not have visibility on and wouldn't have a view on.
Yeah. I'm guessing there's still probably some confusion. Mr Joseph was on a staff, what some people call staff payroll, which is an admin job or a managerial job or a supervisory job, compared with, say, a coal miner at the front line, which would be on a hourly rate.
I would make the distinction that coverage under any industrial arrangements is in some cases a different assessment to eligibility under our scheme. So it's really not appropriate for us to be commenting on those interpretation questions.
I'm just wondering if that's where some of the confusion comes from, because he wouldn't have been, being on the supervisory staff or administrative staff, he wouldn't have been on the Black Coal Mining Industry Award. He would have been staff award, for example. So, does the Coal LSL levy apply to the accident pay component of employee wages when on workers' compensation?
The issue of a employee on workers' compensation is dependent upon the nature of the workers' compensation arrangement with the employer and the employee. So, if the employee remains employed by the employer, then that is leviable, eligible wages. If employment has ceased, then the obligation under our scheme is on the employer. There is no obligation on an insurer under our scheme, so there is no leviable, eligible wages if employment has ceased.
So if the insurer is paying workers' compensation, but the employee has been terminated, there's no obligation on BHP?
That is correct.
And there's no obligation on the insurer to pay either? Is that what you're saying?
That is correct.
Thank you. Should an employee on workers' comp in the black coal mining industry who is medically terminated and who remains on workers' comp continue to accrue Coal LSL leave if they remain incapacitated due to their injuries and condition whilst they continue receiving workers' compensation wages from their... You just answered that question. This gets complex, doesn't it?
How are you going?
Probably another 5 minutes. Well, maybe less, because we're getting to change topic pretty soon, and then it should go quickly. Considering Mr Joseph currently remains on workers' comp... Now you've answered that question. In previous estimates, Department of Employment and Workplace Relations stated a list of around 80 entities who may have been paying levies in error. Has this investigation now concluded?
Paying levies in error?
Yeah. Remember that?
Yes. Yes, that investigation has concluded. It was 28 employers who were paying levy in error, and their levy, 25 of the 28 employers have been refunded that levy amount. The 3 remaining, for I'll say different reasons, still need to be transacted, and that's, we're waiting on the employer to provide information so that we can refund that amount.
So they overpaid?
They incorrectly paid into the scheme.
Too much, okay.
Yep.
Were any of the entities coal services or coal mine services? They wouldn't have been, would they? They don't employ coal miners.
No.
Does the list include any BHP-owned entities?
No.
Okay, change topics. You'll be pleased to know. Move on to the audit. The most recent audit report conducted by Australian National Accounting or Auditing Office, ANAO, of Coal LSL flagged their comments, their quote, higher risk related to both valuation of investments and the valuation of provision for reimbursements. What is the real meaning of these 2 findings of risk as regards the effective operations of and the integrity of the scheme? What are the risks, and to whom are the risks and exposure?
Mr. Wendover will answer that question.
Thank you, Senator. Tony Wendover, Chief Operating Officer. How are you? The external audit focuses on areas of higher risk on our balance sheet, and these particularly would be in areas of our provision for reimbursements, which is a piece of analysis that's conducted by our actuary, but also our investments, as you pointed out. But to be specific, they're around higher areas of risk of misstatement of our financial statements. So if I speak to the first one...
So no financial risk, just a risk of error in your statements? In
the financial statements, that's correct. So if we talk about the first one, the provision for reimbursements, that analysis is conducted by our actuary. It's considered to be an area of higher risk rather than a high risk for the organisation, in that the modelling and the estimations and the assumptions and judgments that go into that, just by its very nature, it's an inherent high risk area, and one that's a recurring area of higher risk, if you like, in our audit reports in previous times, so it's not a new finding for us. The second around investments is around the valuation of our unlisted trusts, and simply the reason why this continues to be a higher area of risk is because of the nature of those investments. Unlisted trusts are considered to be more complex from a valuation standpoint compared to other forms of assets, and certainly if you look at our portfolio, there's a portion of our portfolio that are illiquid assets, and they are also from an auditing standpoint more complex to assess from a valuation standpoint. So that's why the valuation for investments is also considered a high-risk area. And again, Senator, it's something that we've seen in previous audits. It's not a new set of findings for us.
So it doesn't affect the integrity of the scheme?
No,
it's got more to do with assessing the size of the investments, the rates of payout and the rates of income?
That's correct, Senator. So it's the accuracy, it's so that we can stand behind the accuracy of the financial statements. And again, these 2 areas are focused on our balance sheet in particular.
So you said there's no real risk to your entity, to Coal LSL?
That's correct.
So there's not going to be much fallout if the risks crystallise?
They're considered to be high-risk areas, but each year as we work through the audits, we had a successful passing again of this audit of our financial statement, so we're satisfied with that outcome.
So the funds move on to the next part of this. The funds arrive in the accounts of the scheme from compulsory levies upon the relevant employers, right?
Correct.
The funds held by the fund are now in excess of $2 billion. What happens to the excess income generated from the scheme after leave entitlements are paid out?
You're correct about the size of the fund, Senator. It's $2.6 billion now. We measure the health of that in terms of a fund surplus or a fund coverage ratio, and that's how I'd answer that question, if you like. It remains on the balance sheet, but it's we have some goals that we work towards around the coverage of assets over our liabilities, and we manage to those goals accordingly. And that's how I'd answer that one.
Okay, I'll come back to that in a minute. Not many more to go now, Chair. Emmett J. in the Federal Court in 1998 had emphasised there was a lack of control of the corporation Now, I acknowledge that some years, 27 years ago, there was a lack of control of the corporation by the government and a lack of accountability to the government. Was it a government entity at that time, Coal LSL?
1998, yes, it was 1992 that the entity was established under the Administration Act.
Okay. What change in government, if any, has occurred within Coal LSL since then to tighten it up?
Since 1998? Senator, that's a very big question. So I can talk about what we've done, or since I've been in the organisation, and we've had a lot of conversations around that.
Governance, that was a particularly hot issue, yep.
Yep, I can talk to that specifically. Since 1998,
well,
I wouldn't answer that question.
Thank you. Perhaps it, I hear what you're saying. Perhaps, given that the fund was originally set up as a stopgap measure to build up a money chest, if you like, to cover an estimated shortfall of funds to cover long service claims. Can your office comment on what purpose is satisfied for the fund to continue generating millions of dollars per year after the original purpose was met a quarter of a century ago? Why is it still continuing?
That's a very good policy question. I can talk with passion about the value of the scheme, and I'm the first one to talk about the value of portable long service leave and what it has done for the industry and employees in the industry. What I would say is...
Excuse me for cutting you off. I didn't mean that. You don't have to convince me of that portability. That's fine. What I'm getting to is that my understanding, I think it's correct, is that there was a fund created because there's a shortfall in funds. That now you've got a big, massive surplus in funds. Why is the fund still in existence?
So that would be a question for government, but I do know, I think you're referring to the first reading speech or the explanatory memorandum in 1992, which talked about, why was the fund being created, and the payroll levy was set at 5% at that point of time to get the fund back into...
Comfortable with all of that.
Yeah. So what I would say, though, it wasn't legislated. So there was nothing in the legislation in 1992 that said that to legislate a winding up of the fund. It was, yes, it's in the first reading speech as... is it an intention? I won't comment, but definitely it's in the first reading speech, but that didn't translate into the legislation when the fund and the corporation was established.
Well, what I was getting to, Ms Perks, was that I'm not talking about the original coal mine insurance fund. I'm understanding, I'm a bit hazy on this, but I'm understanding that there was a stopgap measure of an increase in fund to cover a shortfall due to excessive payouts and not enough revenue coming in, probably one of the boom and bust years. So they instituted an additional levy as a temporary stopgap. It's now well past that, and they've got a massive $2.6 billion in funds. You don't need it anymore. Why is it still going?
Why is the fund still going?
The extra fund.
No, the additional payroll levy that you're talking about, no, that was removed in 2008 from memory. So the payroll levy was set, and then there was an additional component added, which made it to a levy of 5%, and that was in place from 1992 through to, I think it's 2005 from memory. When the fund got back into a neutral position, that's when that additional levy component was removed, and our levy has been at 2.7% for many years.
That's what I was getting at,
yeah. Not
the original fund, the stopgap fund. So that has been removed.
Yes.
So this is wrong. Thank you. Thank you. Minister, a question for you. Why is a private company run by the New South Wales Minerals Council, the Queensland Resources Council, and then the Mining and Energy Union, managing billions of dollars contributed compulsorily by employers on behalf of the federal government?
I'll have to take that on notice, Senator Roberts, and see what I can provide you.
Thank you. Before you came into the chair, a lot of the problems have come from entities in the coal sector, have come from entities that have 50% Minerals Council or 50% Minerals Council, Queensland Resources Council, and 50% Mining and Energy Union directors. And there seems to be a very tight cluster of organisations: Coal Mines Insurance, Coal LSL, Coal Services. There's another entity in there too that I've forgotten.
I think the Minister's taking that one later.
Yep. So I'm just trying to give her some background. That's it. Thank you very much.
Thank you, Senator.